Welcome back to Ethics in Physical Activity and Health. Today's topic is going to be about ethics in the workplace. So, as we prepare you for a variety of careers in physical activity and health, this is obviously extremely applicable because you will be out in a variety of workplaces. I'd like to begin today with a quote that I just happened to come along a while ago, and I thought it's really, really nice, resonated with me. So Henry Wadsworth Longfellow once said, "It takes less time to do a thing right than to explain why you did it wrong." So besides being a good human, and striving to do right, it's also just advantageous in a variety of ways. So you can take that for what it's worth. Like I said, just came across it, really liked it, thought I'd share it. Today's topic is ethics in the workplace, but we do need to talk about some laws. In an earlier set of lecture slides, I spoke to the fact that ethics and laws are different. So laws, of course, we must follow, and that is, absolutely true in our profession. And oftentimes, our ethics guide the placement of laws. But, they are separate. It doesn't mean that, and the example I used, I believe, way early on was abortion. So it is legal in some form in the United States, yet some people would find that unethical. So it's a really good example where ethics and law are different. But we're going to start with law because, as I mentioned, you have to, if you're going to be an employee in the health professions, there are several federal laws that you have to follow. We've already talked about HIPAA, the privacy of personally identifiable health information, and you absolutely have to follow that. But there's some additional ones, some that you are probably familiar with. And then also think about this. If you want to ever be a business owner, perhaps have a health promotion company or own your own physical therapy clinic, then these are going to be doubly important because not only are you an employee, but you're responsible for your other employees as well. So the Fair Labor Standards Act, the FLSA, this was passed in 1938, and this you probably learned about this in high school to some degree. This was in response to a lot of things that were happening in post-industrial revolution United States. So low wages, no protection, working long hours, children working in all sorts of manufacturing professions. And so this came about in 1938, which said that there had to be some minimum wage limits. You had to at least pay some set amount to your employees. It did regulate overtime pay standards, and you'll see there, I just like this picture. I like old pictures, and we want the 40-hour work week. And so anything above and beyond that would be considered overtime and should be rewarded with more pay. And then it set guidelines for youth employment, which you probably are familiar with now because you have to get a work permit if you are under a certain age to work. And I remember when I don't know the current laws for 15 or 16-year-olds, but in California, but when I was 16, I had to get a work permit to work at Jack in the Box. So it set those guidelines for youth employment. Now there are some additions to that original Fair Labor Standards Act that directly apply to health care, amongst other professions, but especially to health care. We've got the Equal Pay Act, the Family and Medical Leave Act, which is FMLA, and the Patient Protection and Affordable Care Act, which is Obamacare, or nicknamed Obamacare. So let's talk about each of these. So the Equal Pay Act actually prohibits sex-based wage differences between men and women in the same establishment who perform the same job. This does not mean that men and women will always receive equal pay, because there are a lot of other factors that determine pay rate, such as length of employment, education, experience. People can negotiate for higher wages when they get hired, so on and so forth. But essentially, it sets a standard that says all of those things aside, they should be paid the same doing the same job. That actually, though, is not true. Well, I shouldn't say it's not true. The law is true. But if you do look at the statistics, women are still paid less than men performing the same job. And like I said, that doesn't mean that it's automatically an ethical issue. It may be. But you have to kind of look at those other factors to see why that pay difference is present. And it may be an ethical issue, or it may be pretty clear-cut. The FMLA, the Family and Medical Leave Act, requires employers to allow employees up to 12 weeks of unpaid job-protected leave. So that's the important part here, is that it's not paid, it's unpaid, but for 12 weeks, you can leave work if you have a family or medical issue. And here's some examples, like the birth or care of a child, adopting or accepting foster children, taking care of a sick family member, or your own personal health reason. But the important part here is that it's job protected. So if this is approved, you have to have been employed for a year typically, or some kind of hour requirement before you're protected under this. But that's not too long, in an employment situation. But the important part, like I said, is that it's job protected. So you can leave without fear that your job will be gone when you come back. And in the early 1900s, that was a real fear. If you had to leave for some reason, your job was not protected. So these are all provisions, like I said, under the Fair Labor Standards Act. Now, the Patient Protection and Affordable Care Act, this is much more recent, and as I said earlier, this is nicknamed Obamacare. This was a first attempt to reform health care in many, many years, and it was signed into law in March of 2010, obviously nicknamed Obamacare because President Barack Obama was the one who signed it into law. This law is several hundred pages, and it actually tackles lots of different health care issues. I mean, a lot. So I'll give you some examples. First and foremost, probably the one you're aware of, is being able to stay on your parents' insurance until the age of 26, and you don't have to live with them. That was a big change. So in my early 20s, when I moved out of my parents' house, I no longer was under their insurance. So that was a major plus. I'll just say that right now, for our young individuals, that you can stay on your parents' health insurance for much longer than previously before this law was passed. The other things it does is it protects individuals from losing health insurance because of pre-existing conditions. So many times prior to this law, if you had a pre-existing condition, let's say you had acne or even cancer, then insurance companies could deny you coverage because of that pre-existing condition. And so this law helped with that. It also provided funding for worksite health promotion programs, which was a positive. Now, you probably have heard of how controversial it is, though. And there's a couple different reasons why it's controversial, and it is a partisan issue, meaning typically, this is just typically, not a rule, Democrats typically support the Affordable Care Act, and Republicans do not support it. And so obviously this was passed under a Democratic president. There were some things also in there, like I said, it's several hundred pages, and I'm just giving you some examples of what it did. There was also one of the controversial pieces in the Affordable Care Act, what is called the individual mandate. And so the individual mandate said, this is in a nutshell, of course, according to Dr. L, if you did not have health insurance, you would be financially penalized when you filed taxes. So you'd have to pay a fine, essentially, if you did not have health insurance. The rationale behind that, again, this is the summary according to Dr. L. The rationale is to be able to afford expanded health care coverage for individuals, we have to get the money from somewhere. So the idea is if we can get everybody, as many people enrolled paying insurance premiums as possible, then we should be able to help pay for more coverage. And honestly, I think it's economically sound idea. But the reason that a lot of people did not like the individual mandate is because it did mandate you had to buy health insurance. Now, the ACA also set up exchanges. So, like Covered California is the health insurance exchange in our state. And so that was, but like I said, the individual mandate was the sticky part where it was said you had to get health insurance or be fined. So anyways, you can check out the ACA website and, browse around. You can see the other things that it lays out. But there's been some recent changes. So with the election of the Trump administration, they actually wanted originally to repeal the entire Affordable Care Act. And so they wanted to do, and you probably heard it on the news, repeal and replace. They wanted to completely get rid of this and then replace it with some law that they thought was going to be better. That did not happen. What they were able to do, though, because like I said, it's a partisan issue, so you have to have enough votes in the House and the Senate for this to go through. What they were able to do was repeal the individual mandate. So the individual mandate is no longer in effect. And there are some also other changes to like Medicare, which are one of the other controversial issues, but not nearly as much as the individual mandate. So anyways, the repeal of the individual mandate is now in effect. So I've linked to an article, a PBS article, on how the ACA will change under the Trump administration. Now, clearly, not all of these things have happened yet, and it's almost as if, a lot of these things are still in limbo. So I thought this article was nice to give you I think it lays out 10 things that will happen or potentially happen under the Trump administration. So it's a moving target right now, but in its current form, it is still here to stay, or in its amended form, it is here to stay for now. The Civil Rights Act of 1964 prohibits discrimination of anyone based on sex and race during the hiring, promoting, and firing process. And then Title VII actually changes the wording to include race, color, religion, sex, or national origin. So this was obviously in a time in the Civil Rights era, and so the Civil Rights Act of 64 attempted to prohibit discrimination based on, again, originally primarily sex and race, but has now been expanded. One more here, I believe. So we have the Americans with Disabilities Act, the ADA. This was signed into law in 1992, and it prohibits discrimination of individuals with physical or mental disabilities. And so at least one significant life activity must be affected, and this is just an example: walking, cognition, breathing, communication, sight. And interestingly enough, HIV and AIDS is explicitly listed in the ADA. And it actually makes perfect sense when you see that it was signed into law in 1992. When HIV first really was discovered, it was a real crisis. And I know a lot of you were probably not alive in the 80s, but it was scary and people didn't know much about it. The first documented case that, patient zero was in, I believe, 80 or 81. I can look that up here in a second. But long story short, we're only 10 years into our understanding of HIV and AIDS, and it was killing a lot of individuals. Our treatments were very early in their development, and so there was a lot of stigma around these individuals, and there still is, and there probably is still stigma because it is either transmitted, primarily transmitted either sexually or through needle drug use, which are stigmatizing activities often. So ADA also covers some cases of rehabilitated drug addicts and alcoholics and some instances of obesity. So employers, so I'm going to come back to this because this may be this can be some ethical issues here, but I'm going to finish talking about ADA and then come back to this. Sorry, I'm still trying to find patient zero for the HIV. I'm not finding it quickly. Sorry. But the first known patient died in 1984. Anyways, okay, so the ADA, this law here, says that employers may be required to make reasonable modifications for the employee if that employee has a disability. So you can't discriminate against them as long as you can make reasonable modifications. So a reasonable modification may be providing ramps and handicap accessible bathrooms, and that's actually any new construction has to include these. Older buildings, if they're not ADA compliant, then there's some restrictions put on them. If a business can prove that it would be an undue hardship to do that, then the modifications would not necessarily be required. No matter what, the employee still has to be able to perform the necessary functions of the job. So it would not be considered discrimination, for example, if you have an individual who is wheelchair bound and you have very, very high shelving and you have to be able to lift 100 pounds, above your head over 6 feet or something like that. So they could not do that while being in their chair. So they would not be considered discriminated against. But if you are not hiring someone just because of their disability and they can perform the job with reasonable modifications, that's not allowed. So that's the really important part here. So I'd like to go back to this real quick because obviously I'm laying out laws, and laws sometimes lead to ethical dilemmas. And so with the ACA or the Affordable Care Act, you certainly could talk about some ethical dilemmas there. Should you mandate individuals to buy health insurance coverage? Is that okay? So with the ADA, there are some, with the ADA covering potentially individuals with drug addictions and alcoholism, and some instances of obesity, because now obesity is defined or is included as a disease, then the ADA may cover these individuals. And this can be tricky because a lot of individuals will say, I'm just giving you the arguments, I'm obviously not arguing for any of these things, That's not my job as the instructor here. It's to provide you with this information to think about. But anyways, the argument is that these individuals, or one argument is that these individuals caused their own disability, and therefore they should not be protected under ADA. And you may feel that way, or you may feel that that's completely off base, and that's fine. But because these things are classified as diseases, they may be covered under ADA. I'll give you one example of a instance of obesity that ADA covered. It happens to be someone I know worked at Home Depot, and there was a very large, very, very, very large woman who was a cashier, and she, because of her weight and health issues due to her weight, she was not able to stand for long periods of time. Well, clearly then, as a cashier at Home Depot working 8-hour shifts, that was going to be a problem. So, to be ADA compliant, the Home Depot had to think about, can we make a reasonable modification? And so they did. And the reasonable modification was to just provide a high stool so that this employee who could not stand for long periods could sit at the cash register and still perform the job, but have a modification. So a stool would be considered a reasonable modification in that instance of obesity. And so that person was protected, they got the reasonable modification, and all was well. So up to you to think about this and decide if these individuals should or shouldn't be covered, but there are many cases that are. Let's talk about OSHA then. So I lied. I have, I think, one more law here. OSHA is the Occupational Health and Safety Act, and this came about in the 70s. And it's responsible for regulating the safety and health conditions of most work environments. And in in one sentence, what does it do? It says that employers must maintain a safe work environment for employees and patrons, and they have to provide training for those employees. Why is this such a problem? Well, why? Well, first of all, you may have done OSHA training at your other occupations or in your other jobs. Even if you work at Target, I'm sure you did OSHA training, and it might be online or watch a video. Like when I was like I said, 16-year-old at Jack in the Box, I think we watched a video about OSHA. And so they have to train you as well so that they can maintain as safe a work environment as possible. On the job, injuries and illnesses were quite prevalent when this law came about. And if you look at the statistics, more people are injured in healthcare and social services than in any other industry. And there's probably several reasons for that. There's a lot of individuals that work in healthcare and social services. And there's a lot of, mobile jobs. So this is a prevalent issue for individuals in healthcare. What are some other things that can happen while working in healthcare? And this is just a wide swath of examples because you may or may not have these issues in your workplace, but you might. Exposure to bloodborne pathogens, biological hazards, chemicals, drugs, ergonomic hazards, workplace violence, unfortunately, in healthcare. This is all too common. An example would be patients getting physical with nurses that are in hospitals, or physical therapists or occupational therapists that are trying to help their clients in a hospital setting. Patients can become agitated and violent. So that can happen. Lab hazards, and then, things like radiation. If you're an X-ray tech, you have to take all those precautions to make sure that you are staying safe. And like I said, just a small sampling of some risks for injuries in healthcare. So the employer's responsibilities are to raise awareness of potential risks and then train employees in safe practices, especially for that workplace. So this could be including proper disposal of hazardous waste or biological waste or blood and needles, so on and so forth, biohazard, proper lifting technique. That's even doubly important if you are in a physical activity profession, because you will also be teaching others to do this. So that's important. And so that's kind of OSHA in a nutshell for this class. Like I said, I wanted to run through a handful of laws that really affect the workplace. So yes, it's different than ethics, but I think with just letting you know about the ADA, some ethical dilemmas with that, some ethical dilemmas with the Affordable Care Act, that you can kind of see how these things are interwoven. And they're not clear often. It's often not super clear how they're interwoven. Chances are, because you're going to have a wonderful degree soon, you will probably have the chance in your career to hire individuals. And that's, of course, true if you're going to have your own physical therapy clinic or whatever that might be. Or you just might be climbing the ladder and have a management position in your health promotion world. Whatever it is, you may interview individuals. And I hope your human resources office will help you with that. But you have to be aware of this. There's some questions that you cannot ask while interviewing. There are both legitimate and illegitimate questions that can be asked regarding some sensitive topics, or maybe you don't feel they're sensitive, but they're kind of classified as sensitive. Citizenship, age, family history, disability, criminal record, marital status, so on and so forth. So I wanted to mention this just so you keep that in the back of your mind. Interviewing an individual is not a free-for-all. And there's actually a really nice table in your textbook on page 89 that gives you the proper language for asking those legitimate and legal questions. And it's also just related to that. It is also best to have a interview script so that you do have the same questions asked and you don't make an error, so that you just kind of cover your bases. So you pick out your questions ahead of time that you're going to ask everybody, and then have kind of that in front of you while you interview. I think that's a really nice idea. And like I said, it helps you to actually use the language that you intend to use with every person that you interview. And so just to wrap up here and thinking about all these different, for you, think about whatever career you're interested in. How might you interact with individuals? And oftentimes ethical dilemmas arise because you're working with all sorts of different types of people with all sorts of different types of beliefs. And so think about those roles and how they interact. Obviously, if you're going to be a physical therapist in an inpatient setting, you're going to actually work closely with the surgeon, because you will likely, as the physical therapist, be in with the patient pre-op, post-op, and then visiting them every day. And you will probably be following surgeon recommendations. So you will work with that person. Or, think about a long-term care facility for whatever it might be. And you have all sorts of medical professionals, nursing assistants, dietitians, speech therapists, OTs, PTs, recreational therapists. And so all of these individuals are kind of like, moving parts that all have their role in healthcare. So you have to think of scope of practice. Why I say this is that every type of profession has what we call a scope of practice, which means you can only do what that certification or license says you can do. So if you work outside of your scope of practice, it may be illegal, first of all, but also it may be downright unethical. So if you have not been trained very well in nutrition and dietetics, let's say you had one class, and you are hired as a recreational therapist for a long-term care facility, you are not to provide nutrition guidance to individuals. You can do like overall activities and things like that, because if you're a recreational therapist, maybe you decide to have a cooking class and you want to bring in fresh fruits and veggies and so on and so forth. That's fine. So that's why you really have to know what your scope of practice is so that you don't work outside of that. And actually, I'll just personally share this with you. I've been to massage therapists before that I feel work outside their scope of practice. So a massage therapist I went to once really was acting like a physical therapist, and I found that wholly inappropriate. That is only my opinion and an example. But you may notice this. The reason I bring that up is because you may notice this. And so I didn't go back to her, first of all, because I felt that her training and her licensure was not what she was practicing. So she was definitely practicing more what a physical therapist would do, not a massage therapist would do. So being aware, I'm going to run through kind of a few professions, scope of practice. And so you may be able to direct others to the appropriate professional. So if you're a dietitian, and when I say dietitian here, I'm saying registered dietitian. Anybody can call themselves a nutritionist. You can call yourself a nutritionist without any degree at all. But a registered dietitian means that they have been licensed and registered, and they have passed, or they have a degree in dietetics and have done, it's a very extensive internship. So these individuals provide expertise in food and nutrition and can assist patients in diet planning, and they can actually work with individuals with disease. Fitness trainer or personal trainer provides guidance toward health and wellness through exercise. You can still give general nutrition advice as you're working as a personal trainer, but this is where things get sticky because there's lots of different certifications for personal training. Personal training is not regulated. Like physical therapy or medicine. So if you are a physical therapist, if you're a nurse, you get licensed through the state in which you are practicing, and you don't have to do that as a personal trainer. So there you can get into some trouble. I shouldn't say trouble. You get into sticky situations because there are a lot of people who can practice. I mean, you can practice as a personal trainer without a certification. You can call yourself a personal trainer and people can come to you. So it's not regulated like medicine is. So this is a very sticky one. A physician, on the other hand, is licensed, and they have a very clear scope of practice, which is diagnosis and treatment of illnesses and injuries. And of course, there's a variety of specialties. That's the other important thing about this, is that physicians diagnose and treat. Allied health professionals do not. Allied health professionals support and provide guidance in a variety of ways. So a nurse, an occupational therapist, I want to go to that one real quick, provides therapy related to daily tasks with a focus on fine motor skills. A physical therapist provides therapy to regain skills after injury or illness with focus on large motor skills. But they are not diagnosing, right? They're supporting that. And athletic trainers are much the same way. And then finally, nurse performs various duties depending on their degree and state regulations. And so that does vary state to state. But they do all provide health-related care for patients and families in a variety of settings. So what should you do no matter what your profession is? Well, you want to keep up to date with training and education in the field. Chances are you want to work towards improving individuals so that society can be improved. I know that sounds really big and scary, but you are. You're gonna help keep the world, hopefully a good place. Standard of professionalism would also be complying with laws and regulations, acting in a trustworthy manner towards clients, employers, and colleagues, and completing job tasks in a prompt and dependable manner. Here are your organizations, just to wrap up. This is just a variety. This is just a sampling. But if you want more information about each of these careers and what's required to be this type of professional, check out their organization. So a lot of you are probably interested in OT and PT or exercise. And so ACSM and NSCA are our go-to organizations. So you explore these websites. They all have websites, of course, and see what it takes to be this professional, this type of professional, because some of them require certification and license, and then some do not. So like those personal trainers or nutritionists, there's no certifications or licensure required. So there are lots, though, that have certification and licensure required, like athletic trainers, like nurses, PTs, OTs, physicians assistants. And then once you go through the process of becoming certified or licensed, then you are held to the association's standard and ethical practices. And so you read the ACSM little section there about their certified professionals. So their certified professionals are, they have that little code of conduct that they're supposed to follow, and if they are deemed not practicing within that code of conduct, then they can actually be disciplined, if you will. So ethics violations and reporting, you should report at the place of employment first. So someone in HR, your supervisor, maybe you have an anonymous kind of like tip box. But depending on where you're at, you may have to file a complaint with the licensing board, wherever that is. So if it's a physician, it may be state medical board, or if it's a physical therapist or occupational therapist, then you need to go to the licensing board. So I can't, like I said, because we have about 20 different careers that a lot of you are probably interested in, I'm not going to go over all of those. But when you see unethical behavior happening, there are typically outlets that you can use. Now, if you have an individual like a physical therapist or a physician that actually has an ethics violation complaint brought against them, and that can be from you or anybody, then the licensing board's going to complete an investigation. And, just like any investigation, they're going to get evidence. And if there's any witnesses, they'll report their findings. And depending on the severity of the violation, people do lose their jobs or their license, and so you may have doctors that lose their medical license. Now, if it's a criminal charge, that is treated differently. If an employee commits a crime, then that has to go to appropriate authorities. If it's strictly, an in-house issue or an ethical issue, then that's not criminal. It just depends on the situation. So what a lot of people, or I should say work sites, do is they use a progressive discipline model rather than terminating right away. But like I said, it totally depends on the violation. And so you may have seen this because lots of places have this progressive discipline model. So it may be that, the first time you do something, you get counseling and a verbal warning. And then the second time you do it, you get a written warning. And then the third time you do it, you get suspended. And then you get a fourth chance. And if you do it again, then they'll terminate you. The number one reason for individuals entering this progressive discipline model is arriving to work late. And some of you may have been nodding your head at that because if you've worked for Target or Bevmo or wherever, Best Buy, late arrivals go through this progressive discipline model. It might look a little different than this, but typically you get the verbal warning first, then the written warning, then the more progressive, and then eventually you'll get fired. So, like I said, anything criminal is treated as such. And so, in summary, if we think about these legal aspects and then the potential ethical issues surrounding them within this healthcare environment, it's going to really help, I hope, prevent any issues when you're running a successful healthcare business. And you may not be running it, you may just be operating within it, or you may be, middle management, so you may be a supervisor or something. But either way, thinking about these things, or at least knowing them in the back of your head, and then seeking out the experts when needed is going to be very, very good for your professional career, because you just don't want anything popping up that is going to ruin not just your professional career, but others. And so, like I said, you're not going to know all of the laws, but being able to recognize when things seem a little off is probably helpful. And then recognizing, of course, these big laws are going to be extremely helpful. So that is ethics. That's our intro, if you will, to ethics in the workplace. And as always, reading the textbook to solidify these subjects is really helpful. So I would encourage you to do that. And otherwise, have a good one, and you'll hear from me again soon.